Please be seated.
Mr. Gosnell.
Sorry to detain you with this, Mr. President, but 3 transcript corrections.
Yes.
Yesterday, 34570, line 8, should read from page 34325. Today, page 7, line 3. The footnote referred to is 4408. At page 28 of today's transcript, line 20, the phrase should be absolutely nothing improper. Thank you, Mr. President.
Thank you, Mr. Gosnell. One moment, Ms. Favreau. Okay. Yes, Madame Favreau.
Mr. President, Your Honours, at the close of this trial, the prosecution's final brief and their oral arguments are the best evidence of the prosecution's inability to establish the responsibility of General Miletic. Both the final brief and the oral arguments are based on mischaracterization and an artificial interpretation of evidence, as well as on blatantly incorrect conclusions. To start with, let me say a few words about the plan that was allegedly envisaged by the military and political Serb leadership in 1992, and that allegedly was applied throughout the war. I do not intend to dwell on this period, which is outside the indictment. But the prosecution's conclusions referring thereto, which somehow incriminate the entire VRS and even the entire Serb people, cannot be left unanswered. At paragraph 68 of their closing brief, the prosecution quotes Colonel Lazic as saying that the main objective of the VRS was to defend the Serb population, and if there was no other solution available, then to separate all of us, he said, on ethnic principles. The conclusion drawn by the prosecution is that the objective of the VRS was the forcible transfer of Muslims or ethnic cleansing. This is a misstatement. This conclusion is incorrect because Colonel Lazic was not speaking about forcibly transferring Muslims. The allegation that the very objective of the VRS was to transfer population or ethnically cleanse the population would mean that the VRS was in and of itself a criminal organization, and that therefore each and every VRS member, by the mere fact that they belonged to the VRS, was a member of a criminal enterprise. This is obviously not the case. The war in Bosnia and Herzegovina was ethnic by nature, which has been acknowledged by the prosecutor himself in paragraph 165 of their final brief. Those who were unlucky enough to experience a war know that, contrary to what General Smith would like us to believe, war is nothing but immense suffering. War brings nothing but fear, pain, and tragedy. It is common knowledge that forcible transfer is banned in law. But Colonel Lazic was not speaking about forcible transfer. He was speaking about separating peoples at war, a separation which would have limited suffering when there was no other alternative possible any longer. I would like to recall that in an advisory opinion, the Permanent Court of International Justice wrote in 1930 in the case of the Greco-Bulgarian communities that, I quote, "The general purpose of this instrument is thus, by as wide a measure of reciprocal emigration as possible, to eliminate or reduce in the Balkans the centers of irredentist agitation, which was shown by the history of the preceding periods to have been so often the cause of lamentable incidents or serious conflicts, and to render more effective than in the past the process of pacification in the countries of Eastern Europe." This opinion was about the Balkans and the tragic events experienced by the peoples in the Balkans throughout the 20th century and in the war that broke out in 1990 in the former Yugoslavia shows, even 80 years later, how wise the opinion was. The policy of a people and of its army cannot be assessed broadly, generally, in a vacuum. It must be placed in its own historical and social context. In this context, the separation Colonel Lazic was speaking about did not mean moving population. It meant the creation of distinct entities, the Serb entity and the Muslim entity, which was eventually achieved with the signing of the Dayton Accords. At the end of the 20th century, Yugoslavia broke up into several states. The foundation of this breakup was ethnicity. The Soviet Union broke up on the same ethnic lines, and so was the case with Czechoslovakia. Like anywhere else, the peoples of Bosnia and Herzegovina no longer wanted to live in one and the same state. The war did not break out because the Serbs and the Muslims did not want to live in a common state, but because they were not able to reach an agreement and to part in peace. Forcible transfer is a crime. Separating peoples is a way of avoiding war, suffering, and tragedy. Colonel Lazic had this type of separation in mind when he spoke. War cannot be and is not an excuse for crimes, and those who commit crimes have to answer for them. However, the Army of Republika Srpska, the VRS, was not a criminal organization. It was the army of the Serbian people in Bosnia. The fact that General Militic was part of the VRS is in itself of no importance, of no significance. General Militic, just as many members of the VRS, had no criminal intent. He did not intend to forcibly transfer the Muslim population, and he did not at all want to take part in any such enterprise. Let me now address some of the prosecutor's allegations that not only failed to be supported by any evidence whatsoever, but also squarely fall outside the scope of the indictment with regard to General Militic, and this calls for a few preliminary remarks. When the prosecutors sought to join cases, the Militic defense opposed the motion, as it found the indictment, if it were to be joined, was confused, and as such was prejudicial to the accused. Because faced with a confused indictment, an accused is not in a position to understand the nature and the cause of the charges against him. The Militic defense also filed a preliminary motion in which it underscored that the indictment was not clear enough as to whether General Militic was charged with taking part in a single criminal enterprise or in the two criminal enterprises alleged in the indictment. After the Militic defense filed their motion, the trial chamber issued a decision on the 31st of May 2006 in which it held that paragraph 47 at paragraph 47 that General Militic was accused as member of the JCE, aiming at the forcible transfer of the Muslim population, and that he was accused solely as a member of that criminal enterprise. The prosecutor did not appeal the decision. Paragraph 97 of the indictment was mentioned by the prosecutor in support of their case that General Militic was allegedly a member of the JCE aiming at committing murders, and that it was identical to Annex A of the indictment that was the object of our preliminary motion and of your decision of 31st of May 2006. An accused is not a member of a JCE because it is so alleged in an indictment. It must be proven that an accused was a member of a joint criminal enterprise. The presumption of innocence is the very foundation of any criminal proceeding. It is enshrined in Article 21.3 of the statute of our tribunal. The prosecution case that General Militic was allegedly a member of a joint criminal enterprise that aimed at committing murders, although he was not charged with participating in such a criminal enterprise, disregards every single principle of criminal law, flies in the face of any legal reasoning, and is not permissible. The established case law requires that an indictment contain specific charges, and taking into account the 31st of May 2006 decision. The paragraphs of the prosecution's final brief referring to the alleged participation of General Militic in the JCE aiming at murders must squarely be disregarded. Neither the murders in Nezuk, neither the murders of Muslims taken to the military hospital, or the transfer of bodies to secondary graves are part of the charges against General Militic. The allegations regarding the above acts may not be taken into account to establish the criminal intent of General Militic, because, as was held by the trial chamber in the Djordjevic case, intent can be inferred only from facts that are clearly alleged in the indictment. Equally, the prosecutor may not now infer General Militic's intent from the knowledge he allegedly had of acts and conducts prior to March 1995. If the prosecutor sought to prove his intention through events that were prior to the 8th of March 1995, the prosecutor had to say so in the indictment, which he did not do. It was not done either in the pretrial brief or in the opening statement. Further to the appeals chamber established case law, the prosecutor is not allowed to change his case without formally seeking leave to amend the indictment. If the trial proceedings, as they progress, do not confirm the prosecution's initial case. Equally, the trial chamber is not allowed to base its findings on facts that have not been properly alleged in the indictment. Let me say a few words about the section of the prosecution's final brief about the Muslim column that left Srebrenica. At paragraph 1700, the prosecutor makes allegations on the part played by General Militic in the follow-up of the Muslim column. At the hearing of the 3rd of September 2009, the prosecutor expressed their novel, previously unheard of position that the column and the people in the column were part of forcible transfer. I shall not repeat the arguments showing that this column was a legitimate military target, which was confirmed, by the way, even by the prosecutor's military expert, Richard Butler, on the 23rd of January 2008, transcript pages 2244 and 2245. I wish to underscore the prosecutor's statements, who said on 2 occasions in no uncertain terms that this column was indeed a military column, that it attacked Serbian positions, and especially that it was not part of the indictment. This was said on the 1st of November 2006, page 3382, and on the 7th of February 2007, transcript pages 7041. The prosecutor's interpretation of the facts at the hearing of the 3rd of September 2009 runs contrary to the testimony of Richard Butler, who testified that in spite of the presence of civilians in the column was a legitimate military target. But even more serious than that, this new interpretation by the prosecutor stands in contradiction to the prosecutor's very statement regarding the column. The prosecution cannot change facts as it suits them. If the acts aimed at neutralizing militarily the column are to be interpreted as a contribution to JCE, the prosecutor should not have said that the column was not part of the indictment. The accused is entitled to know the charges against him. And when the prosecutor said on the record that the column was not part of the indictment, how could the accused surmise that the prosecutor would change their case in their closing arguments? But that's not all. The prosecutor, lacking any evidence against General Milicic, is now trying to incriminate him for other facts that have never been alleged. The prosecutor never alleged that General Milicic played any part in requisitioning the buses that were to transport the population. However, in their closing brief, the prosecution is seeking to accuse General Milicic of mobilizing, of requisitioning. Of course, there is no evidence to show any link between General Milicic and the requisitioning operation. But if the allegation was part of the alleged contribution of General Milicic to the JCE, it should have been stated expressly in the indictment. The same applies to the arms supplied to Drina Corps units during the Krivaya operation. There is no evidence to support the prosecution's case. But further than that, the prosecutor never alleged that General Milicic was in any way involved in supplying weapons. Also, the prosecutor never alleged that General Milicic or the officers of the operations organ were in any way involved in drafting the orders of the 10th and the 13th of July 1995. These are exhibits P181 and P45. Drafting orders is no evidence. It is a material fact, just as requisitioning is, just as supplying arms is. A possible participation by General Milicic in these acts could be found as the accused's contribution to JCE. However, if such acts are to represent General Militich's alleged contribution to the JCE, they should have been set out expressly in the indictment, and they were not. Neither were they in the pretrial brief or the opening statement. Even during Rule 98 bis arguments at the end of the prosecution case, the prosecutor never alleged that General Militich did in any way take part in drafting the orders, in requisitioning buses, and in supplying the Grüne Corps units with weapons. Furthermore, on several occasions in their final brief, the prosecution alleged that the officers of operations for operations subordinated to General Militich committed certain acts. With regard to General Militich's responsibility, his alleged participation in JCE, the prosecutor must prove that he had a personal contribution to it through his personal and individual acts. What other officers may have done, even if they were General Militich's subordinates, may not be held against him for the sake of his participation to the joint criminal enterprise. Lastly, allow me a few remarks on paragraph 75b and c of the indictment. These paragraphs contain the English word monitor. This word has always been translated into BCS, into the BCS version of the indictment, with the word supervise. At the hearing of the 26th of November 2008, the prosecutor explained that this was not about supervision, but about follow-up. However, the prosecutor never sought to correct the BCS version of the indictment. He just said that BCS is not an official language of the tribunal.
For the record, I think, because it will be better, what's the word in BCS that is used in the BCS version of the indictment, please?
Nadzirati.
Nadzirati. N-A-D-Z-I-R-A-T-I.
Thank you, madam.
The rules governing official languages do not apply here. What applies is Article 21.4.a of the statute that guarantees that the accused is entitled to know the nature and the cause of the charges in a language that he understands. To the extent that General Militich could understand the indictment, he was charged with supervising specific activities. A new term was used in November 2008, over 2 years after the commencement of the trial, and this is obviously prejudicial to the accused. Furthermore, this change was made after the testimony of 2 defense witnesses who confirmed that General Militich was not in charge of supervising the activities of VRS units or of supervising the activities of enemy units. These were Lyubomir Obradović, 17th of November 2008, transcript pages 28288 and 28295, and Novica Simic, 19th of November 2008, transcript pages 28511. The indictment is a prosecution instrument. The prosecutor should have made sure that the BCS translation met their intentions. The word monitor can be translated in two ways into BCS, by the word supervising or the word follow-up. So this is not a translation error. This is about an ambiguous term used by the prosecutor that cannot be held or interpreted to the detriment of the accused. Before analyzing the case against General Miletić, I'd like to say a few words about the evidence. First of all, I'd like to speak about the testimony of General Milovanovic. Basically, the entire prosecution case against General Miletić, and especially the section regarding the post and position of General Miletić, as well as his role in drafting Directive Number 7, rely on the testimony of General Milovanovic. General Milovanovic is a prosecution witness. However, even the prosecutor challenged his credibility when it came to Directive Number 4 in their brief and Directive Number 7 at the hearing of 2nd of September 2009. We agree with the prosecutor here when he says that the testimony of General Milovanovic lacks credibility with regard to the directives. But we also believe that General Milovanovic is not credible when he speaks about the duties and the position of General Miletić. The reason why he testified is simply that he was seeking to elude or at least minimize his own responsibility. Unfortunately, when General Milovanovic testified, the defense did not have in their possession documents showing that he was present. He being General Milovanovic, he was present at the main staff headquarters in the spring of 1995. The defense did not have documents showing that he was fully cognizant of Directive Number 7 and showing acts that he undertook in the Drina Corps area of responsibility and until the 1st of June 1995. All these documents were obtained much later. The key document, which is the diary of President Karadzic's secretary, was obtained only in September 2008. Indeed, a large amount of documents, most of which were favorable to the defense, were obtained in this trial at a very late stage of the proceedings. We do regret the situation, but I'd like to underline that we do not mean to say that the prosecutor behaved improperly. With regard to the other evidence, I'd like to dwell for a moment on intercepts that are a considerable part of the case file. They must be assessed with the utmost care, especially when the intercepts are contain remarks showing that there are disruptions or changes in voices. We also must pay particular care to dates, names of participants, and the names of people being mentioned. Errors cannot be ruled out. The remarks on disruptions and changes in voices show that audibility and therefore understanding conversations was a difficult task. Therefore, the margin or likelihood of errors in these conversations is higher. The content of an intercept. that was not corroborated by other evidence should be disregarded. Let me remind you the testimony of PW147, an operator who admitted that in specific situations, the events that actually took place were the opposite of what had been noted in the conversation. This was said on the 24th of January 2007, transcript pages 6329, 6330. Even though the case law does not require testimony to be corroborated, this is necessary for testimony under 92 bis when the author of the statement is not called to testify and when the witness could not be cross-examined. Elements of such a statement cannot lead to a finding of guilt if they are not corroborated. I would like to deal with a point of law that we raised in paragraph 610 and 611, which has to do with deporting the Muslim men from Jepa. These arguments have been set out regarding Jepa. They apply as well to the column that left from Srebrenica and to forcible transfer that would, according to the new positions taken by the prosecutor, that would apply to the column. As said in our brief, we took note of the case law for victims of crimes against humanity. But I hail from civil law, and I find it somewhat difficult to accept this position. Criminal law calls for a restrictive and strict interpretation. The statute of this tribunal has the force of law. Article 5 of the statute imposes general conditions that have to be met for any crime against humanity. The article provides that the International Tribunal shall have the power to prosecute persons held responsible for the following crimes: when committed in armed conflict, whether international or internal in character, and directed against any civilian population. Article 5 is different from the provisions that can be found in other international texts regarding crimes against humanity, including in the statute for the ICTR and the statute of the ICC, which require that murders must be committed as part of a general wide-scale and systematic attack. That's for the ICTR, and wide-scale or large-scale and systematic for the ICC. In this tribunal, the requirement of a systematic or wide-scale attack was added by jurisprudence as a necessary requirement for the crime to be a crime against humanity. This is understandable, but this does not prejudice the accused, and this is not outside a restrictive interpretation of the law. However, this generalized or systematic attack is a requirement established by case law. It is not a statutory requirement. Article 5 of the statute makes no mention of a generalized or systematic attack. The only mention is a mention of a armed conflict. Since there is no mention of attack in the wording, this kind of mention cannot be held as an attack. The accused can only be held responsible for the crimes as mentioned. This article, at least in its French version, requires that crimes be directed against a civilian population. This being said, let me specify that we are of the view that the presence of a few military inside a civilian population is not going to change anything to the civilian character of the population, but also that a military unit or a group of combatants able to fight that would be totally separated from the civilian population cannot be held as victims of a crime against humanity as set out in the ICTY statute. With regard to the column that left from Srebrenica, those who joined the column did so in order to contribute to the military actions, which was the breakout of the 28th Division from Srebrenica towards central Bosnia. As they had joined a military formation, they became combatants. This applies to the members of the 285 Brigade of JEPA and those who joined them. Both the 28th Division and the 285th Brigade left Srebrenica and JEPA with the intent of joining or going to Muslim-held territory and, if need be, to fight the Serb forces. Activities by Serb forces directed against such groups were purely military activities. Before I move to analyze the alleged participation of General Milicic in the JCE, I want to stress that there is no evidence showing that General Milicic ordered or planned the alleged crimes, which has been alleged by the prosecution in their brief. Although the prosecutor hinted that a host of documents transmitted by General Milicic incurred his responsibility for ordering criminal acts, the prosecution failed to specify a single order or a crime that would have resulted from carrying out such an order. If, further to the tribunal's case law, a person can be held responsible for ordering, even if that said person did nothing but transmit the order, and if the order was not issued in a particular form, the prosecutor has to specify the particular order giving rise to the accused's responsibility for ordering. That would be a crime under the tribunal statute. The prosecution must also prove that the order was unlawful and had been transmitted in the knowledge that a crime could have been committed in carrying out the said order. Finally, the prosecutor must prove that the ordered crime was indeed committed. In the present case, the prosecutor has failed to adduce any evidence that General Milicic ever ordered a crime. At paragraphs 1741 and 1743 of their brief, the prosecution alleged that General Milicic planned the crimes. Paragraph 1743 is in and of itself contradictory, because the prosecutor first alleged that General Milicic assisted in planning the crimes, only to say later that he had a central role in planning the strategy that was later implemented by the RS and VRS leadership, which eventually led to the enclaves being taken and the population, the Muslim population, being moved. First of all, planning a crime and planning a strategy that may have led to a crime being committed are two very different things. The first implies the direct planning of a criminal act, for instance, moving the population. The second, in terms of planning an act that is perfectly lawful, but then later led to a crime being committed. Planning a strategy that led to the commission of a crime is not planning as understood in Article 7.1 of the statute, but it can be tantamount to contributing to a joint criminal enterprise. There is no evidence in the case file to support the case that General Milicic planned criminal acts. Later on, I shall return to the role General Milicic played in drafting Directive Number 7, but for the time being, let me just say that the case that General Milicic planned the strategy that was later implemented by the RS leadership is totally illogical. It is obvious that the strategy applied by the political and military leaders could only be planned by the latter, and certainly not by an officer who was not among the leaders. The prosecutor tells you that he does not seek the conviction of General Milicic because he was the chief of the Administration for Operational Affairs and Training in the VRS. But that's precisely what the prosecutor does. He accused precisely General Milicic, and solely because of the position he held. Look at the entire case against General Milicic. The prosecutor's brief, their closing arguments, everything relies on the phrase that he should have known. Only last Friday, page 34279, the prosecutor said the following sentence: "It is inconceivable for the chiefs of operation not to know." But that's not the question at issue. And it should not be the question at issue for a criminal trial. But let's start with the beginning. And it must be said that the prosecutor mischaracterized the position held by General Milicic throughout the war. For instance, it emerges from paragraph 69 of the prosecutor's brief that Colonel Lazic was subordinate to General Milicic. The prosecutor refers to not a single shred of evidence confirming this, and he could not have, because Colonel Lazic, who left the Department for Operations of the main staff on the 21st of May 1993, was never subordinated to General Milicic. This is confirmed by Exhibit P3178. Also, the prosecutor claims at paragraph 1662 of their brief that General Milicic was the assistant chief for operations before he became the chief of operations in June 1993. First of all, the position of chief of operation is not known within the VRS, and it is impossible to understand whether the prosecutor had in mind the chief of administration for operations and training or the chief of the department for operations. It must be said for the prosecutor that General Milovanovic, whose testimony was mentioned by the prosecutor, was very vague on this point. However, concrete evidence of the position held by General Milicic is given by Exhibit P3178. It shows clearly that General Milicic was never the assistant chief for the administration of operations and training, and that he never held any position or duties in the Department for Operations. Exhibit P3178 is credible evidence that was, by the way, referred to on many occasions by the prosecutor. At paragraph 1662, the prosecutor alleged that General Milicic was in the organs for operations at the time Directive 4 was drafted, and also at the time when there were military activities in Česka, end of 1992, beginning of 1993. But such allegations are not supported by any evidence and run contrary to this exhibit I have already mentioned, P3178. The prosecutor also claims that General Miletic was involved in drafting the analysis on combat readiness for the year 1992, and that he had to help his superior Dragutin Ilic draft the analysis. The prosecutor refers to Richard Butler, who testified that General Miletic was subordinated to Dragutin Ilic, but who never said that he was involved in drafting the analysis. Furthermore, what General Miletic had to do was of no significance. The prosecutor should have proven what General Miletic actually did, but the prosecutor failed to prove any involvement of General Miletic in drafting the analysis on combat readiness for the year 1992. The prosecutor made allegations about the duration of General Miletic's participation in Operation Spring. It was wrong. Draghi Marcel said that the operation lasted at most 1 week to 10 days. He said so on the 2nd of December 2008, transcript pages 29143. Indeed, the Operation Spring lasted exactly 5 days, from the 3rd to the 8th of May 1993. The 1st of May 93 order, Exhibit P2742, mentioned by the prosecutor, shows that the operation started on the 3rd of May. And the operation did indeed end with the creation of the safe area in Jepa on the 8th of May 1993, which has been acknowledged by the prosecutor. But let us look at the meaning of this 1st of May order and what General Miletic may have understood of it. In paragraph 1665, the prosecutor reaches a conclusion that is obviously wrong when he says that the order given by General Miletic on the 1st of May 1993 is an attempt to reach the 3rd strategic objective, which is to move Muslims out of the Drina Valley. The 1st of May 1993 order is not an order given by the man who was then Colonel Miletic. It is an order by General Milovanovic. Furthermore, the prosecutor concluded that this operation aimed at deporting or transferring Muslims. This is not a reasonable conclusion, quite the contrary. The sole objective of this order is clearly spelled out in the items 4 and 5. It was exclusively to attack the Muslim forces. The order provided for the possibility for the Muslim population to stay or to leave for central Bosnia. This possibility did not mean that the population would be forcibly transferred. Movement of population was not necessarily the objective of the attack. It was often the consequence of military activities and of the change of rule. In the 1st of May 1993 order, this possibility was foreseen, but it was not envisaged with the aim of forcing the population to leave, but in order to make sure that it would be safe if it decided to leave. The prosecutor acknowledges that the attack in Jepa in May 1993 ended with the creation of the safe area. Together with the safe area being created, Jepa should have been demilitarized. It is obvious that the VRS thought that the objectives of the spring operation had been achieved with the zone being demilitarized, which is something the VRS main staff believed in at the time. The end of military activity when the zone was demilitarized shows that the purpose of the operation was not to transfer population, that it was indeed to neutralize Muslim forces, which is a natural and legitimate objective in any armed conflict. Directive number 6, Exhibit P39-19, also shows that transfer of the Muslim population was not an objective of the VRS. This directive was issued in 1993 after the demilitarized zones were created, and it did not mention the Drina Valley among the objectives of the VRS. Demilitarization of the zones under Muslim rule in the Drina Valley was the purpose of all the VRS activities in the zone. The documents of the VRS cannot be interpreted in the vacuum or in the light of events that occurred 2 years later. Any document must be assessed in the context in which it was written. The possibility was given to civilian population to go in the order of the 1st of May, but it was not expressing an intention to transfer the Muslim population. It only expressed the fact that a population often follows their army. So, contrary to the prosecutor's allegation, this sentence shows that when the order was drafted, all the steps were taken to ensure the safety of the civilian population. The way the prosecutor interpreted this order shows that the prosecutor totally disregards the armed conflict, the objective of which was to defeat the enemy forces. Contrary to the prosecutor's conclusion, there can be no unlawful meaning to be attributed to VRS documents when there is a reasonable military explanation. The 1st of May 1993 order is a military document that is perfectly regular and lawful, that allows for no other interpretation. The participation of General Miletich in the spring operation was military justified, was perfectly lawful. No criminal intent can be inferred therefrom. The way the prosecutor interpreted the 1st of May 1993 order is very relevant. And indeed, the prosecutor endeavors to assign to all VRS documents, regardless of their actual contents and objective, an unlawful purpose, because the prosecutor interprets them ex post facto, seeking in them a harbinger of tragic events that took place in July 1995. Such an approach is not helpful for the trial chamber, because the trial chamber must infer criminal intent from an act if there is no other reasonable. We have to look at the prosecutor assigns all the acts of the main staff to General Miletich only.
Pendant tout le procès,
Throughout the trial, the prosecutor sought to position General Milicic at a post or a position that was not his, and to ascribe to him knowledge regarding the situation on the front, in subordinate units, in the sector of intelligence, logistics, mobilization, and in any other facet of the work done by the VRS. Knowledge that went way beyond the commander's actual knowledge. Obviously, this case cannot be supported and is not supported by any single evidence, and it is totally wrong. General Milicic is not the main staff. His possible contribution to the alleged JCE can only be assessed on the basis of his own conduct. The acts by the main staff cannot be ascribed to General Milicic unless they are acts in which his participation has been established. General Milicic was not the commander of the main staff. He was not supposed to know everything that may have happened at the level of the main staff. He cannot be held responsible for each and every action by the main staff. Whatever the position and the duties held by a General Milicic, the function, the position in and on of itself cannot be the evidence of his alleged membership in the JCE, nor of his alleged contribution to it. The prosecutor spent a large part of this trial and of his final brief to the general's duties in order to conceal the paucity of evidence they had to prove his alleged criminal responsibility. I am not going to address the arguments we have in our final brief as to his duties. They show clearly that General Milicic never had the authority and the powers of the Chief of Staff, and that never he was the main advisor to General Mladic. I shall just underline some of the prosecutor's conclusions that are totally unfounded. When he tried to explain what General Milicic's duty was, the prosecutor referred mainly to General Milovanovic's testimony in paragraphs 635 to 653. The prosecutor mentioned General Milovanovic 25 times. But the prosecutor says so himself. He said that General Milovanovic was not a credible witness. And when the prosecutor does not refer to General Milovanovic, he quotes the regulations 7D410 applicable to corps, army corps, whereas corps are units with a structure, organization, and operation that are very different from those of the main staff. So this evidence is just as unconclusive as General Milovanovic's testimony when it comes to General Milicic's responsibility. This evidence fails to reflect the true duties of General Milicic, do not allow to infer what he really did. This evidence says nothing as to his task at the time of the activities around Srebrenica and Sheba. When the commander, the chief of staff, and many assistant commanders were absent from the main staff, and when the situation was very remote from the regular situation described by General Milovanovic, and was very different from the situation set out in the above-mentioned regulations. Let it be noted that the regulation applied to core units and also that they were to be applied in peacetime. You will find an illustration of the utter uselessness of this evidence in the prosecutor's allegation that General Miletić should have made suggestions to General Mladić as to the way to engage the units. Not surprisingly, the evidence quoted by the prosecutor is General Milovanovic's testimony. However, what matters in this trial is not whether General Miletić could or should have suggested the way to engage units, but whether he did so for the Drina Corps units for the period from March to August 1995. There is no single piece of evidence to confirm that General Miletić would have done so. There is indeed no evidence that General Miletić made any suggestion at all to General Mladić, or that General Mladić ever consulted him. General Milovanovic was the confidential advisor of General Mladić throughout the war. He said so himself. General Mladić himself acknowledged at the end of the war that General Milovanovic held a privileged position. He made a speech at the beginning of 1996 in which General Mladić expressed his gratitude and his thankfulness to General Milovanovic in the following terms. Once again, a special thank you to you, General Milovanovic in particular, my right hand, who very successfully stood in for me at all difficult moments and helped me enormously. At the hearing of 7th of September, the prosecutor stated that the presence of General Milovanovic at the main staff headquarters did not change much as to the position held by General Miletić. However, in paragraph 11 of the indictment, the prosecutor described General Miletić as the main advisor to General Mladić, precisely because he represented General Milovanovic. But if General Milovanovic was present at the main staff headquarters, nobody could have represented him. The defense contends that General Miletić was never General Mladić's main advisor, whether Milovanovic was present or not. However, the statement by the prosecutor that the return of General Milovanovic changed nothing to the situation for General Miletić, and this is absolutely void of any logic. Furthermore, the prosecutor uses different methods to assess the role of General Miletić and the role played by General Milovanovic. If the prosecutor is to be believed, the mere fact that General Milovanovic left the main staff headquarters would exonerate him of any responsibility, although he was sent on the ground precisely to assess the situation and precisely in order to gather information that he would take to General Mladić. On the other hand, it is said that General Miletić, even when he's on leave in Belgrade, could have sought to be informed as to the situation. This is absurd, especially so if you factor in that General Milovanovic was, without the shadow of a doubt, and throughout the war, the main associate, the closest associate, the most appreciated associate of General Mladić. It is not disputed that General Milicic worked with Milovanovic. He was subordinated to General Milovanovic. But this is of no assistance to the prosecutor, because General Milovanovic, under the indictment, is not a member of the joint criminal enterprise. Process. General Mladic did not mention him as one of his close associates in the speech he made at the end of the war. This is Exhibit 5D 1441. The prosecutor remained silent regarding General Mladic's speech, although the speech is crucial evidence when it comes to assessing the part played by General Milicic. General Mladic was speaking in front of his associates, in front of officers who knew what roles the members of the main staff played, and in front of people in front of which he had no reason not to mention his close associates. General Milicic was present when General Mladic made the speech, and if he had been one of his close associates, it is sure that General Mladic would not have forgotten to mention him. Since General Milicic was not among the inner circles of General Mladic's closest team workers, team members, it is hard to imagine that he may have been in the unique position of advising General Mladic. Indeed, for General Milicic to be in the position of providing advice to General Mladic, it would have been necessary for Mladic to give him the opportunity to do so, therefore to ask him for advice. The prosecutor failed to provide any evidence that General Mladic ever addressed or turned to General Milicic for advice, or that General Milicic ever provided such advice. The only such piece of evidence is document 5D 1016, a 1994 document. However, in this document, General Milicic did nothing but pass on to General Mladic a proposal made by the Drina Corps commander. Furthermore, this document shows that General Mladic did not accept the proposal made by the Drina Corps commander, and that he had a different opinion than General Milicic, or rather, that General Milicic did not agree with General Mladic's decision. At paragraph 1650, the prosecutor alleges that the influence of General Milicic in the main staff increased, and that his proposals were complied with, were accepted. All this is not supported by evidence. General Milicic was the only general in the main staff who was not mentioned expressly in General Mladic's speech at the end of the war. Furthermore, the conversation between General Mladic and General Tolimir on the 24th of July 1905, this is Exhibit P1327, is a good indicator of the degree to which General Mladic would respect and accept proposals made by General Miletić. In this conversation, General Mladic did not even take into account the opinion expressed by General Miletić, and he ordered precisely the opposite to General Tolimier. Equally, the prosecutor has no evidence to substantiate his allegations that General Miletić had an essential role in each of the decisions taken to further the objective of the alleged JCE, and that General Miletić's decisions were crucial in the efforts undertaken to defeat militarily the Muslim forces and to transfer the Muslim population out of Srebrenica and Jepa. The prosecutor fails to refer to any decision by General Miletić. He can't do so because there is no such thing as a decision issued by General Miletić. At paragraph 131 of their brief, the prosecution quoted General Nicolai, who testified that the answers, useful answers to the VRS main staff could be obtained only from generals, because generals were probably the only one authorized to make any decisions. General Miletić was a colonel until the end of June 1995. Therefore, if General Nicolai is to be believed, and supposedly the prosecutor believed him because he quoted him, General Miletić, at least until the end of June 1995, could not have played any essential role in the decision-making process. General Mladic was the commander of the VRS, and is certainly better placed than General Nicolai to say who within the main staff took part in the decision-making progress. That's precisely what he did in this speech that I've mentioned several times. General Mladic listed the officers who took part in taking decisions. In doing so, he made no mention of General Miletić. Let me now address the issue of humanitarian aid before I tackle the issue of the directive, because I think there is no link between the two. First of all, there is no evidence of a specific policy by the VRS regarding the supply of humanitarian aid to the eastern Bosnian enclaves. With regard to humanitarian aid, the defense found themselves in a quandary, because, as was stated in our brief, and as you've noted yourselves, certain important facts that were unfavorable to the defense were taken judicial notice of. And the position of for the defense was even more difficult because documents regarding a humanitarian aid are held by organizations that are in no obligation to cooperate with the tribunal. We are all aware of the position adopted by international humanitarian organizations when it comes to producing their documents, and there's no need to dwell on the issue. However, although the defense had the burden of adducing evidence to refute facts and judicial notice, the prosecutor had the burden of proof beyond any reasonable doubt. Yet the evidence adduced at trial cast a serious doubt on the prosecution's allegation. The evidence adduced at trial no longer allowed the finding that in early 1995, there were less and less humanitarian convoys that reached Srebrenica. It is no longer possible to find that the Bosnian Serbs deliberately tried to impede access to enclaves and that blocking humanitarian convoys was part of a plan. You have a chart on page 21 of Exhibit P4145. It proves beyond all reasonable doubt that humanitarian aid was supplied to the eastern Bosnian enclaves, including Srebrenica and Žepa, on a regular basis until June 1995. There was no reduction that would have resulted from the Directive number 7 being issued. This exhibit, P4145, is undoubtedly the best evidence with regard to the humanitarian aid supplied to the enclaves. This exhibit proves that the Srebrenica and Žepa enclaves were better supplied than the other enclaves in Bosnia, that the aid supplied in March, April, and May 1995 actually increased compared to February 1995, and that at any rate in 1995 until June 1995, it was supplied much more regularly than it was in 1994. Exhibit P4145 is a document that comes from the organization that is best positioned to know the situation in terms of humanitarian aid and the volumes of humanitarian aid provided. It would not make sense to disregard this exhibit for the sake of testimony that, in the light of this exhibit, appeared to be totally wrong. I can only regret that this international organization did not wish to let the defense access their archives. The requests made to the Serbian authorities and the answers could not be accessed either. These are documents that could have demonstrated with even more cogency that there was no plan to restrict humanitarian aid. The testimony referred to by the prosecutor in support of their case is evidence that, in the absence of further evidence, led this tribunal to determine in previous cases that humanitarian aid had been deliberately restricted as of the beginning of 1995. I'm speaking of the testimony of Dutchman members, of Johannes Rutten, for instance, who can only remember a single UNHCR convoy in March 1995, whilst Exhibit P4145 shows us that 11 convoys reached the enclave. Witness Rutten does not remember a single UNHCR convoy in April, whilst there were 10 that brought larger quantities of humanitarian aid than the 11 convoys in March. This testimony by witness Robert Rutten is to be found in page 5231, hearing of 7th of December 2006. But this is also what Robert Franken testified. He could not remember any problems with the UNHCR. He only remembered after he read an excerpt of the NEOD report, 5D54. He only then remembered that he had tried to impose a control of the UNHCR convoy, but he could not remember that the said convoy had failed to enter Srebrenica precisely because of what he had done, because of what he had decided. 18th of October 2006 hearing, transcript pages 2639, 2640. We're now in June 1995. The Muslim forces have launched a generalized offensive on the Serb positions, including in Sarajevo. But the forces in Srebrenica and JEPA also contributed, as is shown by Exhibit 5D229. However, the UNHCR convoy bound for Srebrenica was allowed to pass through by the Serb authorities. It went through the VRS checkpoint, but it did not enter Srebrenica. In June 1995, the humanitarian situation was difficult everywhere. It was difficult in Srebrenica as well, but Robert Franken, the assistant commander of the Dutch BAT, decided at the ABRH request to impose control of the UNHCR convoy, which caused the convoy to depart, which caused the convoy not to supplying the aid it had brought. Robert Franken forgot the UNHCR convoy. He also forgot that the Dutch BAT that he commanded in second used to seek supplies from Bratonats. Of course, there were restrictions, but they were limited in nature, and above all, they had not been imposed in order to create living conditions that would be unbearable for the Muslim populations. They were the result of numerous abuses by the ABRH and by those who transported humanitarian aid. Nobody can rule out the possibility that restrictions, if any, were justified. Let me take the example quoted by the prosecutor, the case of a truck transporting school supplies. This ban seems odd. Why should one ban school supplies? Very simply, because the request was made in June. In June, children are on holiday. However, the ABRH could make good use of copybooks that were to be used initially by children. Everybody remembers the copybooks used by the intercept operators. Just have a look at them. Look, for instance, at P2328. You will see that these were copybooks used by children, but this time they had been used for military purposes by the army of Bosnia and Herzegovina. I would like to add a few words regarding medical supplies. The prosecutor claims that there was nobody left in Potocari when 5D 1446, this report, was drafted. The report only supports the experts of the NEOD report that was inadvertently omitted from footnote 568 in our defense final brief. Of course, there were still wounded people in Potocari on the 13th of July 1995. They were evacuated only on the 18th of July 1995. Even Robert Franken admitted that there were wounded left in the Potocari base after the population had been evacuated. Ilko Costa testified too in his 92-ter statement that the wounded stayed in the Dutch BAT base. The UNMO report of 17th of July 1995, P524, confirms that on the 17th of July 1995, the wounded people were still in Potocari. Could we move to closed session, Mr. President?
Let's go into private session, please. Yeah, anytime it's convenient for Madame Favot, we have the usual break.
Peut-être on peut faire la pause maintenant.
We could have a break now.
Thank you. 25 minutes. Thank you.
All rise for your levé.